All right, hello everyone. And today we are going to discuss the topic of even a minor injury can turn into a multi-million dollar case. And Mitch has the perfect example. Welcome to another segment of Live with Mitch, brought to you by Proner and Proner, a law firm with a global presence and expertise that feels local and personal. I'm your host, Mel Maguia. Today, we sit down with the expert himself, Mitch Proner, a personal injury attorney with over 30 years of experience here to answer your questions and share insights you'll find useful in the personal injury world. And remember, all consultations are free and confidential. Reach us at any time at 1-800-321-1234. How you doing, Mitch?
Doing great, doing great. So had a great result in court this
Yep.
week, and very excited about it.
Yeah, I can't wait to hear. I know this is a case you and the team have been working on for a long time. So yeah, it's such good news. So yeah, you know what? I'm gonna let you tell the story because this is a good one.
So to say a long time is an understatement. This case was it was unreal. So
Yeah.
what happened was we started to pick a jury. I picked a jury with my associate Daisy Koch was with me. Um, so we start to pick the jury before Thanksgiving.
Oh wow.
Now, I go first, and then my adversary goes. When I started, my adversary was, I could say obtrusive, but I prefer to say obnoxious. He repeatedly interrupted me, and you're supposed to take turns speaking. It's not supposed to go back and forth um, like a Jerry Springer episode. But he kept interrupting me, and I pushed through it. And then the next morning, he starts off and he says, the reason why I repeatedly had to interrupt the plaintiff's attorney was because I had to keep him honest. And
That's right.
that's a rule you don't violate. You're not supposed to attack opposing counsel. And that's where he started. So I thought he crossed the line. So I brought him to the judge because you pick a jury without a judge present in the city. In other venues, the judge is there from the start to the end. Even upstate New York, the judge is there from the start to the end.
Okay.
Upstate New York, your client is with you traditionally during jury selection. In the city, traditionally, the clients are not there. It's just local custom and practice. So, anyway, we go before the judge, and the judge disbands the jury. Now, the defense attorneys, they get paid by the hour. For me, I only get paid at the end if I'm successful. So for them to disband the jury, they're working on the hour. It's no hardship for me. Basically, my work was for nothing. So now I got to start all over the new panel, and we don't finish before Thanksgiving. So the judge says, come back after Thanksgiving. And then the case stops uh, December 16th and starts up again January 7th. And then it ends up going until February 2nd. So the case literally went from before Thanksgiving to February,
Wow.
which is a long trial. And prior to jury selection, my adversary said to me, when this case is over, I'm going to be drinking champagne. And my client, we were representing my client for the first accident. And then while that case was being litigated, he gets into a second accident.
Oh no.
The second accident case settled, and the first accident case was going to trial. Since I represented the same client for both accident cases, the defense counsel said, you're trying to get paid twice for the same injuries, and you're double dipping, and I'm going to prove it to the jury. Well, I said, for the second accident case, which was settled, that was done. I said for the first accident case, which was going to trial, I said I would take 2.5 million. The other side said they offered 1.8. The insurance guy was in court during the trial, not speaking. He doesn't speak before the jury, of course, but he was in the audience every day.
Wow.
And he said to me, "We'll pay any number as long as it doesn't begin with a 2 to settle the case." And I said, my number is 2.5. Now, every time I make a demand, anytime there's an offer, I speak it over with the client. And I tell them, this is the offer. This is what I want to demand. But if you want to accept the offer, the case is over. And he said, no, I'll go with you. I said, you understand that we lose, you don't get anything. We could lose. He said, I understand. I'm going with your advice. So I held the line at 2.5. They never came up. They said, any number with the 2. I said, no, the number's 2.5. We continue with the trial. So, matter of fact, I thought the case was going on well.
Okay.
I thought it was going on well, but you can never be certain. Anyway, the jury came back 36.4 million.
That's amazing. Were you expecting that by any means?
No. No.
That's amazing.
No. Anybody that tells you they can predict what a jury's going to do is not being honest.
Right.
You could try the same case with the same attorneys, the same arguments, the same proof in front of the same judge with the exact same trial. And if you put that same trial in front of 50 different juries, each jury is going to come back with a different number.
Right.
And generally, some of the numbers you're going to be happy with, some you'll be disappointed with, and some are going to fall somewhere in the middle. But you never know what any particular jury is going to do. What you try and do is you do your best to pick a good jury. You get challenges. There are 2 types of challenges. There are challenges for cause, meaning a witness has said they know one of the parties, they know a witness, they know one of the doctors. They might have particular experience in the type of accident that occurred. For example, let's suppose it was a case involving an air traffic controller.
Okay.
And you had somebody on the jury that says, I'm an air traffic controller and I know all about it. Maybe they would say, something, this guy sort of got too much of his, or perfect example. Sometimes somebody shows up and they might be in the insurance industry. And all day long, what they do is deny claims. They might have a bias. So as a matter of law, they get off. So that's a challenge for cause. Then there are what's called peremptory challenges. Peremptory challenges are just for any reason you could exercise it. So you might have someone that demographically seems perfect for your case. They seem like the perfect juror on paper. They got the right career, they got the right background, and you're talking to them, and for some reason, you just don't like them. Well, chances are, when you're talking to somebody, if you don't like them, chances are they don't like you either. And you're better off using a peremptory challenge on that individual, even if they're on paper, they seem perfect for the case. So you get peremptory challenges. There's a limit to them. You get 3 for the panel and 1 for 2 alternates. And you get challenges for cause, and you try and do your best to pick a good jury. And there are ways that you could find out what's going to be a good juror for a particular case, and I'm not going to share all my secrets. But it comes with You can do focus groups. Yeah, can have experience, and there are things that we do to find the right jurors. But even still, it's you do your best, and then the same thing with you. You got to prepare for every witness, and the preparation is exhaustive. And then when I'm on trial, my wife could tell anyone I don't sleep. I'm awake every night thinking about every facet of the trial, and it's a lot of work. And I work 7 days a week. Just because court is 5 days doesn't mean I'm not working all weekend long with my witnesses, with my evidence, and a lot of times it's demonstrative evidence. I'm working with artists on my exhibits. They're medical legal artists that show these surgeries. There are PowerPoints that we use during our summation, our closing arguments, and getting the slides ready as the evidence comes in. It's a lot of work. For this summation that I gave on the $36.4 million case, I had over 70 different slides that I showed in my PowerPoint.
Wow.
And I was working on that PowerPoint the Sunday before I gave my summation on Monday.
Wow.
And I came home from the office on Sunday at 7:30 at night. And I got there at 9 o'clock in the morning.
Wow.
And I was on the phone with my associate at 8 o'clock. And she was working on it too. So it's a lot of work. It doesn't happen by wishing. But for my client, it was a successful outcome. He said during my summation that he said, "You were like a poet." and you know, it doesn't happen by wishing. It's a lot of practice. It's a lot of work. And fortunately, there's nothing more gratifying than being successful on behalf of a client that deserves it.
Yeah, that's amazing. So if you don't mind me asking just one question, what do you think was probably the most challenging part of it all, besides the time frame?
So every dog has its fleas. And there were a lot of issues in the case that were challenging to overcome. So first of all, the injuries involved in the case, well, even before you get to the injuries, the way the incident occurred, there were no witnesses supporting my client's version.
Oh,
As a matter of fact, the witnesses were blaming my client for the way it happened.
okay.
They said it was his fault, that he was reckless. So I started off the case by cross-examining the witnesses that were against him on liability. So before I ever put my client on the stand, I beat up the witnesses that were against him. And obviously I had to be effective in that because we were successful. So that was the first challenge of the case. Nobody supported his version of how this incident occurred. Nobody. It was just his word.
Right.
Secondly, when the incident happened, he just had 4 stitches in his forearm. That was the only injury, a laceration on his forearm. Third of all, my client didn't speak English.
Oh, wow.
Was an undocumented laborer who was paid in cash. So there was no proof of his lost earnings.
Oh, wow.
And nobody said that he was as hardworking as he was. His employer, who he'd worked for 13 years, came into court and said, no, he just worked for me for a few months.
Oh, wow.
And he was an independent contractor. And his coworker said that he warned my client and my client was at fault for the incident.
Mm-hmm.
And so that was challenging. On top of that, he has 4 stitches in his arm, goes to the hospital, gets treated, had pains in other parts of his body, called me up, and we sent him to doctors that were near him.
Okay.
The other side was saying it was our doctors that were making up injuries. And the guy was fined for the hospital records. But the fact of the matter, he was treating, and he had recurrent neck pain and shoulder pain and headaches. So we got him to a headache specialist, and he got shoulder surgery. And then he gets into a second accident, a motor vehicle accident, where he gets hit in the rear by a truck. And he hurts his ankle and his knee and gets surgery in the ankle and the knee as a result of the second accident. They did testing on his head right before the motor vehicle accident. It was an MRI with DTI and neuroquant. It's this very specialized type of test. And it came back positive. And it showed that he had temporal lobe atrophy, which showed trauma from the incident. This was a construction accident. Now, the defense attorneys had doctors, neuroradiologists, neurologists that said my client was fine. There was no brain injury. And the lawyer argued any brain injury was from the second accident. And they had a neuroradiologist, board certified neuroradiologist, went to court and said, this testing is junk science. It's a toy. But he conceded on cross-examination that this testing was approved by the FDA. But the neuroradiologist, their doctor said, oh, but that's only for Alzheimer's, not for diagnosis of brain injury. And then ultimately my client gets neck surgery, a anterior cervical discectomy infusion. So he had the shoulder surgery, he had the neck surgery, and he had a brain injury.
Wow.
And he never went back to work. One of the doctors for the second accident put in his medical records that my client was back to work full time before the motor vehicle accident.
Oh, wow.
And the defense attorneys called him as a witness. They paid the doctor from the second accident $15,000 to come into court. And they pulled the history that he got that it said that my client was back at work full time. And they were so smug about that, like they won. This defense attorney, he was the one that said to me during jury selection, he would be sipping champagne at the end of the trial. Well, when I had that doctor on the stand, I had him concede he didn't speak Spanish. He was using a translator. On top of that, in his records, that he wrote down the name of the shoulder surgery, the shoulder surgeon, and he got that name wrong. He said that according to the client, he never had an MRI of the knee before the second accident, when it turned out he had an MRI of the knee a year prior. So I said, so your history is faulty, or my client's a poor historian. And he said, yes. I said, and you didn't speak Spanish, so you don't even know if you got a good translation. He said, that's true, it happens. So there were a lot of problems that I had to work with. I had to work with the fact that the initial incident didn't diagnose a head injury. They didn't do any testing. He denied a loss of consciousness. And there was a second accident. And the neck surgery was after the second accident. So there were a lot of problems. But obviously, we overcame those problems. And I got past the defense witnesses. And we had a successful result.
That is amazing. That's so amazing. I know you guys worked really hard on that, and I'm sure we can go on for the whole day and hear all the details. But yeah, Mitch, thank you for sharing that story with us. I'm sure our listeners will greatly appreciate it, and will hopefully learn from your winnings, so to speak. Well, there you have it, folks. Straight from the expert himself, Mitch Proner. That'll wrap it up for now. Thank you for taking the time to tune in, whether it's on our podcast or video broadcast. We really do appreciate it. And remember, you can reach us 24/7 at 1-800-321-1234, where all consultations are free and confidential. If you haven't done it yet, follow us on Instagram, TikTok, Facebook, and YouTube. Like, share, and please subscribe to get the latest updates. Now, before we go, Mitch, is there anything else you want to add?
Yeah, I'm passionate about what I do and my representation of my clients. And to consult with us is always free and it's confidential. And if you've had an incident where you sustained injuries and you believe somebody else at fault, consult with us and we'll do our best to help you out.
Amazing. Well, thank you again, Mitch, for another informative session. And thank you all for checking us out. I know I learned a lot, and I hope you all did too. Thank you again, Mitch, and congratulations.
Thank you, Mel.
Anytime.
Thanks for listening.
Of course.
Hi, I'm Mitchell Proner. We just had a successful day in court. My associate, Daisy Koch. We had a case that seemed like a small accident initially. It was a construction worker that was installing a rack refrigeration system into the basement of a supermarket and fell down a ramp, sustaining a cut on his forearm that required 4 stitches in the emergency room. At first, it seemed like a small case. Afterwards, it got infected. It turned out there was a little piece of metal in there that needed to be removed with a secondary surgical procedure. My client had ongoing shoulder, neck and back, and headaches. The shoulder ended up requiring arthroscopic surgery. The neck required a procedure called an ACDF, anterior cervical discectomy and fusion, which is a pretty serious surgery. And worst of all, the headaches came with other problems. He got diagnosed with a mild traumatic brain, and a special test called an MRI with diffuse tensor imaging and neuroquant showed brain atrophy in the left temporal lobe, meaning there was permanent damage structurally. We demanded $2.5 million. The supermarket said 1.8. They said they would pay any number as long as it didn't begin with a 2. My client considered the offer and said he was prepared to go to trial. The jury came back, $36.4 million. It was a good day in court. At Proner & Proner, we're going to try and get you a settlement as quickly as possible for as much money as possible. But if the offer is inadequate and you want to go to trial, we're prepared to try the case and do what it takes to win. Proner & Proner.